they wanted directors and officers to take care when they're writing these reports. And they thought, how can we do this? Well, if we attach direct liability to any false or misleading statement put in there, that will make the directors and officers of any corporation perk up and say, we need to do this. We need to do this right, because not only is it the company's reputation at stake, it's me personally.
Human trafficking doesn't always take the form we first imagine. It can be found at almost any level of an organization's supply chain. What can compliance professionals do to assess human trafficking risk, and how can they leverage the resources of the organizations they work for to help root out this tragic problem? Gwen Hassan is here to help. This is Hidden Traffic.
Hello, and welcome to another episode of Hidden Traffic. I am your host, Gwen Hassan, and I am thrilled today to have Sean Stephenson with me. Sean is joining us from Canada. He is in Toronto, where he works as an attorney for Dentons, the Dentons law firm, which, for those of you who don't know, is a large multinational, multi-service law firm. So welcome, Sean. I'm really glad to have you here today.
Thank you.
So let's dive in and learn, first of all, a little bit about you. Tell us about yourself. How did you end up working for Dentons and working in this particular practice area? And do you love Toronto and what's going on?
I'd have to say I do very much like Toronto, and I say that as not a Toronto native. It's my city by adoption, but I think it's fabulous and would welcome everyone to come and visit. I've worked for Dentons for about the past 5 years. Before that, for about another 5, I worked at a boutique law firm, again, here in Toronto. And all of that work was essentially in the trade and investment space. So when I envisioned my perfect career, I wanted a career in international law. So that has focused to a certain amount of elements on public international law and others on sort of more transnational or cross-border type of law. Generally, that focuses on trade and investment.
We have that in common, actually. When I went to law school, I wanted the same thing. I wanted an international law career. It sounded very glamorous. And it has been sometimes, but it's also been a 4-foot wide hotel room in far Eastern Europe where I could bump into myself if I turned around too fast. So it's not as glamorous as I thought it would be in law school, but I have really enjoyed it. And it's enabled me, like you, to practice in the trade area and in this area specifically in human trafficking prevention, which I feel passionate about. So I understand the draw is what I'm trying to say.
Yeah, I mean, I think it's a great career. I really liked it so far. In Canada, at least, the practice is sort of a wider breadth than I think you'd get compared to practicing the similar areas in the United States. Now, our practice area goes from anything from advising and acting on WTO cases to free trade agreement cases down to what I call more of the nuts and bolts Canadian law. Your stuff is stopped at the border. And particularly over the last few years, a real focus on supply chain. And that can go from corruption in your supply chain to sanctions in your supply chain to what we've really seen in the past couple of years in Canada. And we'll talk a little bit more about this, is human trafficking, forced labor, and child labor in your supply chains.
Yeah. So I know that practitioners like myself have been following this at least for the last couple of years because of all, and I say this, I mean, supply chain integrity, human trafficking, because of the kind of legislative and regulatory changes we've seen. Of course, there's the weirdly acronymed UFLPA or UFLPA in the United States. There's the new German Supply Chain Act. We're watching carefully that EU CSRD that's coming out. But now, welcome to the party, we have a new Canadian act. What is it called, first of all? I've heard people say it's the Modern Slavery Act of Canada, but I don't think that's actually accurate, right?
That's not 100% accurate.
Okay.
Generally speaking, if you say that, I think you'll probably get people knowing what you mean. The exact name is Fighting Against Forced Labor and Child Labor and Supply Chains Act.
Oh,
I'm not sure how they landed on that specifically, but sort of a longer title. And I think colloquially, many people just say it's Canada's Modern Slavery Act.
Okay. So who is subject to it and when is it going into effect? It was adopted May. Is that right? Am I remembering?
It was adopted of May of this year. I would say it's a long time coming. It was introduced in the Canadian Senate, actually, 3 different times. And for different reasons, the bill didn't move forward. Either an election was called and they had to start anew.
Mm.
So it's been a long time coming. They've been working on this since roughly 2016 to get something in place in Canada. So we say it's new. That is true, but the intention from Canadian legislatures, or at least a small group that sort of expanded, was always to have something like this. So, you saw the UK Act enter into force in 2015, and I think that was a catalyst for Canada to start saying, well, look at some of our peer countries. They're adopting this type of legislation. We should have something similar on the books in Canada. Those concerns have only increased since that time.
Yeah.
And it finally got passed in May of this year, and it's going to enter into force January 1st, 2024.
Ooh, so coming up 6 months-ish from now.
About 6 months. And then the first reporting period falls very shortly after that. So May 31st, 2024. For companies that are caught by the legislation, it's a great time to focus in on what that reporting period is going to mean. And many companies have a long leeway to get these reports drafted, adopted, ensure that they're in the condition that they want them to be in.
Yeah.
Because they are public reports. They're filed not only with the government, but one of the requirements of the law is to have this report posted on your website.
Also, obviously, then the big effort in-house will be to make sure there's consistency across this and, say, your ESG report, right? So you can't say one thing in your Canada, I'm going to call it Modern Slavery Act report, and another thing in your UK report, and another thing in your ESG report. They all need to align.
They all do need to align, and it's
Yeah.
important that there is alignment, or that there's not inconsistencies, or at worst, potentially a misleading or false statement as to
Yeah.
practices going on in the group of companies or the Canadian company specifically.
Theoretically, is it possible that your UK Modern Slavery Act statement and, say, your Australia, if you're doing business there, also Modern Slavery Act statement, can also work in Canada? Or are there special kind of unique requirements under Canada that will make that difficult?
By and large, there's a lot of convergence.
Okay.
All of these laws are kind of getting at similar things. To back up, first of all, who's caught by this legislation?
Yeah.
It's a pretty wide remit in Canada. The legislation is roughly based on another piece of legislation we have in Canada that was adopted a few years ago called the Extractive Sector Transparency Act. That's focused specifically on the extractive sector, saying, look, essentially it's a publish what you pay. So you're paying to certain governments. The sort of gist of that act was rooted largely in corruption, particularly in the extractive sector. The Modern Slavery Act, or the Fighting Against Forced Labor and Child Labor in Supply Chains Act, which is a mouthful.
Yeah.
But it's broader and much broader in nature. It's not specific to the extractive sector. It applies to essentially any business formation. So, if you're a trust, a partnership, an unincorporated organization, it applies to everybody. And there's a couple of sort of threshold criterias that you need to be cognizant of when sort of making that assessment. One, it's, do you produce, sell, or distribute goods in Canada or elsewhere? Essentially.
Well, that's wide open. Yeah. Are you in business? Yes. Okay.
Or do you import goods into Canada? So if you do any of those things, you've checked the first box. The second level of assessment there is, are you listed on any Canadian stock exchange? Or do you meet 2 out of the 3 criteria that they've set out in the legislation, which is 1, having $20 million or more in assets, $40 million in revenue, or 250 employees or more. If you meet 2 out of those 3, and then you essentially do business, as you said, you're then a reporting entity. A lot of companies are being caught on the assets and revenue threshold because, while they sound like relatively large numbers for any mid-sized business, those are easy numbers to obtain.
Yep. They're relatively low, especially when you look at like the EU Act. They have also, I think, a 250 number, but they also then have a 50 number and then a 10 number. We'll see what happens with that when it gets to actual implementation, but their dollar thresholds are higher than 20. So now we know who it applies to and that it's fairly similar to the other acts out there, but it's not just a disclosure act. there's also more to it?
It primarily is a reporting act. That's where it differs from an actual diligence standard. So when you compare it to, for example, what's going on in Germany, you don't have that here. It is a reporting act. And to your point before, could you use your statements that you're creating for the UK, Australia, largely similar in terms of the content that is required?
Okay.
But there's some sort of peculiarities or uniqueness to the Canadian Act. One of the first acts that also really puts a focus on child labor.
Mm,
So that's something that may not be in your existing reports because
yeah.
Canada says, look, we want to focus not only on forced labor as defined in the ILO conventions, but also child labor. So if you're drafting your report, for example, for the UK or for Australia, broadly similar content in terms of what is your structure, what are your policies, what are you doing? That's what we really want to know. Obviously, you look at training, you look at monitoring, you look at when you find an instance of forced labor or modern slavery in your supply chain, how do you go about remediation? All of those things broadly similar and all generally speaking built off of those foundational UN documents, those additional OECD documents. Very similar, but there's that child labor. There's also a couple of other unique components to the Act, which I think in-house counsel definitely need to be aware of. So one, the reports are public. You're filing not only with the government and it will be eventually put up on a government website, but you also have to have it on your website. So your own personal website. For businesses that are incorporated in Canada under the Canada Business Corporations Act, so that's the federal incorporation statute, you also have to send out these reports with your financial reporting document.
Okay.
It has to go directly to shareholders. It sort of increases that level of being a public-facing document.
Yeah. Of the likely scrutiny it's going to get and how likely it is to be read.
Sure. If it's on your website along with your policies and other reporting documents, you might have some keen folks who are very interested in the area looking at these. Obviously, you might have ESG institutional investors who are looking at these things. But when it's just sent to you with all the other financial reporting documents, you might, as a shareholder, take a look at what's going on. The reports also need to be approved by the board, and it needs to be signed off on by at least one board member.
Is that typically the CEO that would do that, do you think?
I mean, it can be the CEO, can be the CFO, the COO, depending if some organizations might have a specific sustainability officer or human rights compliance officer. They have that signing authority that would likely meet the requirements of the Act. But they do so because there's also a few hooks in terms of potential penalties under the Act. If you don't, for example, file the report with the government or don't post it to your website, there are potential penalties that can be assessed against a company. Those fines can go up to $250,000 Canadian. But there's also a specific liability built into the Act for false and misleading statements. Who's ever signing off on those things, not only can the company be liable, but there's also, in addition to the false and misleading statement requirement, there's a specific director and officer liability component to that. So the company can be liable for a false and misleading statement, but also if you are a director or an officer that sort of knowingly signs off on one of these reports and they contain information that is potentially false or misleading, you could be personally liable as well.
Personally liable. Oh. As somebody who works in a corporation, my initial response is, oh, yikes. But as someone who's also really passionate about this area, my second response is, I like that. That's got some teeth. That's good.
And I think to your point, both of these reactions were exactly what they were trying to capture when they were building these specific provisions in there. They wanted directors and officers to take care when they're writing these reports. And they thought, how can we do this? Well, if we attach direct liability to any false or misleading statement put in there, that will make the directors and officers of any corporation perk up and say, we need to do this. We need to do this right, because not only is it the company's reputation at stake, it's me personally. So that was sort of the hook or the interesting part that was added to the Canadian legislation. They didn't include, for example, a due diligence requirement, which many NGOs said we're not going far enough. They did include some hooks in there to say, maybe we're not going as far as some people would like, but we want to ensure that these reports are well done. We want to ensure that this issue is being put on the top of considerations or pile of considerations when we look at sustainability or regulatory compliance for corporations.
So you mentioned kind of due diligence requirements and NGOs, which brings me to my next area of inquiry, which is as an outsider, as an American, I am fascinated by your ombudsperson program up there. I've referred to it or heard it referred to as CORE before, but I think that's Canadian Ombudsperson for Responsible Enterprise. Tell us a little bit about how that program works, how it relates to this new act, and what you think about it was all over the news, the inquiries into Nike and to Dynasty Gold, and how that differs from an NGO. It's not an NGO, but it acts like an NGO. Tell us about it. What does that involve?
So CORE came into fruition a couple of years ago. Last week, released their first two initial investigation reports. So it's not an NGO, it's an ombudsperson. It's an arm of the Canadian federal government. And this forms part and parcel of Canada's response to modern slavery in the supply chain. The mandate is to promote the implementation of the UN and the OECD guidelines on multinational enterprises. And specifically, it focuses on three target areas. So the garment business, mining, and oil and gas. As I'm sure you know, Canada has many mining companies that have operations all over the world. So mining is sort of a critical aspect to the Canadian component. So what does the CORE do? What is their purpose? Anyone can submit complaints to the CORE about business activities of Canadian businesses, either inside Canada or abroad. To a certain extent, it acts like an NCP, like the national contact point for the OECD. However, it has specific powers that are only, it has a statute, it is funded by the Canadian government, so our budget, obviously it's staffed a little bit more aggressively than what your NCP might be, but sort of works in tandem with Canada's NCP. It can look at complaints submitted by individuals, either Canadians or non-Canadians, about the business conduct of Canadian businesses.
And when you say business conduct, that's broader than just human trafficking or forced labor issues. It's any kind of business conduct?
So really, it's looking at human rights abuses.
Human rights, yeah.
If it's unsafe work, unpaid work, child labor, forced labor, discrimination, harassment, land dispossession, pollution, those are all within the remit of CORE, and CORE will actively say, yes, to the extent that you meet our criteria, you are a part of those three sectors, you're a Canadian business. Given that the CORE was established in 2019, they have a sort of timing aspect to the complaints. So they will only look at complaints starting after May 1st, 2019.
2019, okay.
Assuming you meet all of those criteria, the CORE will say, yes, we are happy to take a look at this to facilitate a discussion between the complainant party and the business at issue.
So it's got a little bit of a feel to like the SEC Office of the Whistleblower to it. In the SEC standpoint, it's a regulator, and there's a separate office that handles complaints and investigations and issues raised by whistleblowers. Am I capturing that accurately? I mean, I know that CORE isn't of itself a regulator, but it kind of has the powers of an investigative regulator.
It does. It has some investigative powers. I mean, some of the critiques against CORE is that its powers aren't broad enough to investigate. It can't force document production, for example. So it's really, we will accept the complaints. Generally, they try to work with the complainant and businesses saying, can we sit down at the table? What is the issue? Can we resolve it? There is some investigative powers that CORE does have. They can investigate by themselves, but they can't, for example, require documents to be filed by any party.
So what's the likely outcome then of these announcements recently against Nike? Is it that kind of a sit down? Well, and also Dynasty, where it's like, hey, these are the allegations. How can we work together to figure this out? Or do they have the power to fine people?
For the two most recent, and these are the first cases that have come up, so they've been highlighted because of that. Two, obviously, they're focusing on both the China region. So it's gotten a lot of media attention. So what those are is the CORE's initial assessment. What they have done to this point is they've looked at the complaints saying, okay, you meet all of our sort of threshold jurisdictional criteria. We have talked to both parties. We've talked to the complainants. We've talked to Nike. Where do we go from here? It's the initial assessment. There's been no pronouncement that anything wrong has happened or no findings, essentially. So what they've done is sort of say, for both of these cases, we're going to proceed to an initial investigation. We're going to start down the road, and they themselves have noted, we don't know exactly what we're going to find here. We know we don't have the power to, for example, require document protection from these companies. They can do so voluntarily.
Mm.
They can engage in a mediation between the parties. They agree the parties, they can arbitrate the issue, but they don't have a ton of significant power outside of ensuring that the parties, trying to get them to the table, trying to have them discuss. Now, if the parties want, again, they can agree on arbitration, they can agree on mediation.
Sure.
The Corps, in certain cases, can recommend that matters be referred to Canadian law enforcement and have an investigation that way. They can also come up with just determinations of, based on the evidence that we have, we think that there is human rights abuses. They can also recommend fines, but they can't order.
Okay.
You could come with a recommendation. Those don't have the force of law. But if you have a determination that there is a human rights violation or a recommendation for a fine in concert with that type of determination, as a company, you might be subject to sort of further actions where you say, here's the ombudsperson. They have made a certain determination. If you're an enterprising lawyer or NGO, you might say, well, what could we do with this?
Yes, exactly. And not to mention just the sheer risk of reputational damage. Everyone's already talking about it and nothing's even been investigated yet. So you can never discount the potential for having your name bandied about in the context of human trafficking and child labor. It's never a good thing.
Yeah, companies don't want that. It's something you want to avoid. Obviously, if a complaint is brought against you, you can't avoid it. But going back to the reporting obligations, as a company, you can say, well, we are a good corporate citizen. We are really trying to prevent or reduce all of these things. Here's the suite of due diligence and policies and frameworks that we use, third parties, to really ensure that we're not engaging in these types of things. Or at least then when we find them, we take action. So those are all things that can be very helpful in these types of investigations, showing that you're really trying, that you're actively looking for these types of things. You're actively trying to prevent these types of things.
Yeah. You're on your front foot, not your back foot. You're leaning in and really making a concerted, transparent effort to look at these things in your supply chain. So let's say I'm, a company with offices in Canada, and this podcast is the first time I'm hearing about this. And I have 250 plus employees, and I'm definitely at more than 20 million in terms of turnover. Where do I start? Do you think trade is kind of a natural entry point? Should it be, of course, what everyone always says, start with a risk assessment? What are your thoughts around where to start for companies that are just trying to get their arms around this?
Trade has been the entry point for a lot of companies. Canada does have trade restrictions on goods made in whole or in part by forced labor, so those goods shouldn't be entering. A lot of the initial discussion on this was actually coming from the United States and their enforcement of the UFLPA. We probably need to do something about it. Or if you're a global company, we've put these measures into place for the United States. Should we do this for Canada as well? So trade has been, generally speaking, the starting point for these types of discussions, and then looking at your supply chain and saying, we don't want to deal with a border seizure in Canada or the States.
Exactly.
We probably need to develop policies to ensure that from tip to tail, our supply chain is as good as we can possibly make it. So a risk assessment is a good start. You need to know where your risks are, and that can kind of dictate the policy approach you take internally. That can dictate, your supplier code of conduct. How vigorous do we need to be in really assessing this? Do we need to engage third parties, enhance due diligence? I always think the risk mapping is a good start. It is an ambitious undertaking, and particularly when you start to get to not only your first tier suppliers, but the second tier, third tier, fourth tier. Generally, that's where you might start finding issues. Usually it's not your first tier suppliers.
Yeah.
It's a big project. So it is a good place to start. It can be a little bit daunting, but you can also start with basic measures, supplier codes of conduct, saying this is where we expect you.
Yeah.
And then build it out slowly. You don't need to do
0 to 100 in 5.
0 to 100 in a month or two. You can say, look, this is a process we're going to engage in. And, we strive to continually improve our supply chain management. Then what we've seen also is companies starting here as a starting place for example, human rights compliance, but then they start looking at environmental compliance and scope 1, scope 2, scope 3. We need this anyways. And then even just, we're going to look at the health of our supply chain, generally speaking. Are our suppliers healthy? Are they critical suppliers? How are they doing financially? And you see sort of these full-blown supply chain assessment where companies actually have a much better handle on their goods, not only how they're made from a social environmental perspective, but also the overall health of their suppliers. And do we need to engage in, for example, multi-tiered procurement to ensure that we have significant supplies? Because as we saw, for example, COVID, your suppliers might not be as healthy as you think, or a port strike somewhere in China could significantly impair your business in Europe or the United States or something like that.
Yeah. So just from a smart business practice standpoint, that kind of an assessment makes sense. Separate and apart from, of course, the more moral issue of child labor and human trafficking. When someone undertakes that kind of a risk assessment from a U.S. standpoint, there's a couple of U.S. publications that are out there about high-risk industries and high-risk products. Is there a similar thing in Canada that's published, or do you rely more on like the international guidance from the ILO and those kinds of places?
To date, it's more international guidance.
Okay.
So what's been published at the ILO, other organizations, I mean, also what's been published in other jurisdictions. For example, the US regulators have concerns with certain companies, as they do under the UFLPA. Those concerns are there for a reason. As a Canadian business, you might say, well, we have similar border measures. One day, your goods may be stopped, they may be verified. You might have to go through that process. Here in Canada, enforcement has been significantly less.
Thank you so much. This has been super insightful. Part of the reason I love doing the podcast is because I end up learning just as much as we go along. And so it's been very helpful for me. I want to real quickly highlight that Dentons, when I said you are a multinational full service firm, that's not overstating, right? I mean, I know you do trade, but Dentons does a lot of other things. Yeah.
Yeah, we are, a complete full service law firm, and we've got locations around the world. Those needing to deal with multi-jurisdictional filings, for example, on the reporting obligations, we're seeing that a client in Australia is also filing in Canada and saying, we need help in both jurisdictions. We're filing in the UK or California.
Yeah.
One of those great issues where a big law firm can really show its strengths of saying, we can help you around the world.
In all of those jurisdictions. Yeah. So if someone wants to get in touch with you directly, Sean, or continue the conversation or ask for advice, how do they do that?
The best way would be to send me an email or give me a phone call. If you want, you can just Google Sean Stephenson Dentons and you'll very quickly find the webpage. If not, it's just sean.stephenson@dentons.com, and I would be happy to talk with anybody about this.
Great. Thank you again for joining me today. And I really appreciate your expertise and help.